So if we can start recording. Welcome to Cunningham Legal presents Liabilities and Risks when hiring caregivers in California. You really do need to know this stuff, folks. I've got Nicole Kamm here. She's a great lawyer from Phillips. And in getting ready for this, Nicole, I got to tell you, when we went through these gotchas, I was really surprised. And I've been doing estate planning for over 25 years and been helping clients through this process where they take care of their parents as the parents go through the aging process. So I'm super excited to have you here today to share your wisdom with all the people who are joining us today. So any opening thoughts?
Well, thank you so much. I do believe that this is a very important topic, particularly for those that you work with as they're helping their older family members or a family member that may have a disability or need some special care. So I think that this is a very appropriate topic, and I'm really happy to be joining you today.
So thank you, Nicole. This is so important. Also very important. What we're talking about here today is information only. This is not legal advice. So don't say, "Oh, I saw Nicole say this, Jim say that, and I'm going to go out and do a bunch of stuff." Bad idea. This is information only. And so Nicole, you're at, there's your contact information. You're in the LA area. And let's talk about liabilities and risks when hiring caregivers in California. Take it away.
All right, fantastic. So as you mentioned, I'm an employment attorney with Phillips. My firm is a national employment law firm. We represent only employers in all matters having to do with employees. And one of the areas that I work on that really is closest to my heart are these caregiver matters. And I think after today's webinar, you will absolutely understand why this is such an important area and why I have such passion for working with people that have been put in difficult positions with regard to caregivers that they bring into their home. So I'm going to start off by sharing a story about Sonia and Phil Moberg. They were my clients. I changed the names. This is not really Sonia, but in terms of their story, what is true is that Sonia came to me at 103 years old. Her son was in his 70s, and the two of them had been named as defendants in a lawsuit by two former caregivers. Phil was a retired physician, and he had a relationship with a former nurse who had gone out and started a caregiving business agency. And he had contacted her when Sonia needed some care and asked for a referral. The agency placed a caregiver in the home, or two caregivers rotating, and represented that they were knowledgeable and that they knew how to comply with the law and that they were complying with the law, and paid the caregivers. So Phil and Sonia would pay the agency would pay the caregiver, and so forth. The caregivers ultimately separated from working with Sonia and turned around and filed the lawsuit. And the lawsuit was brought against Sonia and Phil and the agency and the owner of the agency. And the problem here was that it was Sonia and Phil that had the deeper pockets. The agency was not well funded. The owner didn't have any assets of her own. And so when it came to me representing Sonia and Phil, we were in a tough position to try to get them out of the matter and really put the onus on the agency who had guided them, on whom they relied, and who they expected to be complying with the law.
Yeah, Nicole, actually, can I just make kind of an obvious point?
Yeah.
If the agency hired the caregiver, why on earth how could a caregiver even sue Sonia and her son, Phil? And by the way, if you guys have questions, there's a Q&A on your bar there, on your Zoom bar. If you're watching a recording, obviously there's not going to be Q&A because it's recorded. But if there is Q&A, go ahead and put those up, and we'll answer those as all the pieces fit into the our time here today. So how is it that someone can just sue Sonia and Phil when they didn't even hire them? Yeah.
Right. And I'll get into in a couple slides the definition of employer under this particular law, which is called the Domestic Worker Bill of Rights. And that definition of employer is very broad and is really subject to being interpreted in a way that can encompass anybody that controls directly or indirectly the wages, hours, or working conditions of the caregiver. And Sonia and Phil would tell the caregiver how Sonia liked to have her meals prepared and when she wanted to nap and when she wanted to go out for an outing. And Phil was a doctor, and so he instructed the caregiver on how to issue the medication. And because of that, they were considered employers under this broad definition because they had control, even indirect control, over the working conditions of the caregiver.
So what you're saying is Sonia and Phil, even though they were not the employers in air quotes, they were still considered the employers because of this Domestic Worker Act. What is that again?
Domestic Worker Bill of Rights. Exactly.
Domestic Worker Bill of Rights. It sounds kind of scary.
So we ended up litigating the matter for almost a year. We had a mediation where there were 3 different rooms where the parties were all separated, and we ended up resolving the matter for into the 6-figure numbers. We were able to create a situation because we had filed a cross complaint against the agency and the owner of the agency. We had again relied on them. They represented that they knew what they were doing and that they were doing it properly. So we went after them, and we were able to work out a situation where end of the day, my clients did not have to pay or will not have to pay, but they did have to loan money in order for there to be a reasonable settlement to get this matter done. Sadly, Sonia passed away not too long ago, actually at age 105, and really had a long, lovely life. And her son wrote the most wonderful message about her after she passed away. So that was, one of the first situations where I realized really how subject to abuse this area can be, and how elderly people and their family members can be very vulnerable to claims.
Yeah, and when we were getting ready for this, I recalled that we have a client who's also over the age of 100. Incredible life story. A few years ago, she got dinged for, I'm going to say it was almost $200,000.
Uh-huh.
And
Yeah.
this is not, folks, this is not uncommon. This is common. Okay.
Yes.
This is not like, oh, this hardly ever happens. Does this happen a lot, right, Nicole?
Quite a bit. And there are some law firms that on the plaintiff side, on the employee side, that now dedicate themselves only to this particular area of the law. Because I hate to say it, but it really is often the low-hanging fruit where it's very easy to make mistakes. It's very easy for the employers or the individuals not to know what is required. And that's part of what we want to do here today, is we want to be able to provide some information, help educate. Knowledge is power. And absolutely always talk to somebody before you're engaging somebody to provide any sort of caregiving or in-home services. And by the way, these laws also apply to nannies or other in-home caregivers. It's not just caregiving for elderly people. It can also be those who have somebody providing care for their young children or somebody who may have been injured. So really it's anybody in the home. And I'm going to go into a little bit more detail on that. So here's some of the topics that we're going to talk about. And we can go ahead and move on to the first slide, which will give you a little bit of background. So generally, California has certain wage and hour requirements for employees. This is for non-exempt employees, the hourly workers, the workers who are not receiving or generally not receiving a salary. And there's minimum wage requirements, there's overtime, there's meal and rest breaks, and anybody who's either worked or employed employees probably is somewhat familiar with these requirements. It used to be the case that in-home domestic workers were essentially exempt from all these requirements. They were subject to minimum wage, that floor, but there was no overtime, there was no break requirement. And so it was really a much looser type of relationship with those in-home caregivers. In the years prior to 2014, the lobbyists for this industry started pushing to implement different requirements, such as overtime, such as meal and rest break requirements. And it's inconsistent, or it's kind of doesn't line up, because how can somebody who's the only person taking care of an older person or a baby clock out for a 30-minute meal break, right? And they can't leave the premises. Their job is to be there.
Yeah, Nicole, can you just cover what those are, what an exempt worker is, and the 2x minimum wage requirement? And a lot of people watching this are not lawyers; they're just normal people,
right?
And they're like, "You just said a bunch of stuff," and
I
it's
did.
Italian. Okay.
Yeah, and honestly, we could spend days on all of these issues, each of these different topics. But when I say non-exempt, I mean you're subject to minimum wage requirements. You're entitled to overtime. There's meal and rest break requirements, and those requirements may differ based on the industry. An exempt employee is more of the higher level, the managerial, and there is a requirement to be paid 2 times the minimum wage on a salary basis, and that goes up every time the minimum wage goes up. And the more important is to be providing or performing exempt duties more than half the time. So that is a whole very deep area of the law, which we can talk about. But caregivers, for the most part, they're not going to be salaried exempt employees. They're going to be the hourly workers. So, that's really what we should be focusing on today. So leading up to the Domestic Worker Bill of Rights, the good news is that the meal and rest break requirement was not put into play. The bad news is that starting January 1st, 2014, certain domestic workers who are called personal attendants, who are those that I'm going to talk further about, but those that are taking care generally of others who need supervision or care or attention, are now subject to overtime at 9 hours in a day. So generally, we understand that overtime kicks in at 8 hours in a day, 8 in California and 40 on the federal level. Under the Domestic Worker Bill of Rights, we bought ourselves an extra hour. And so overtime, time and a half, the regular rate of pay doesn't kick in until the 9th hour of work. We do also have to look at federal. And even though the Domestic Worker Bill of Rights talks about overtime over 9 hours in a day or 45 in a week, most cases, the caregiver is going to be subject to federal overtime as well, which will bring it down to 40 hours in a week. So you need to be looking at both daily and weekly. And anytime you go over either, we kick into the time and a half. Another point that's positive is that for most general workers, if they work more than 12 hours in a day, they're entitled to double time, so 2 times their hourly rate. That does not apply to domestic workers. It's only time and a half for all hours over 9. So when you start work to the 9th hour of work, it's your straight time rate. 9 to 24, you're at time and a half, and then you start all over again on the next work day. And that's where a lot of clients will get into trouble, because they will pay their caregiver a flat daily rate or a flat weekly rate, or worse, a monthly rate. And the law says that that flat amount does not pay that worker for any overtime hours. So you could be paying that person very generously, and they would be paid 0 for anything beyond 9, is our argument as a defense attorney. Some attorneys will argue on the plaintiff side over 8, but when overtime kicks in at 9, our position is that it's 9. And so the calculation is that we would divide the daily rate divided by 9, that gives you the hourly rate. We need to multiply that times 1.5. And for every hour from 9 to, basically it's going to be 15 hours of unpaid time at that time and a half rate. And that's why these numbers get into the 6 figures very, very quickly.
Yeah, it's important for the people who are watching this to understand that you cannot opt out of these rules. This is the law, and you really need to pay very close attention on what you're paying people, but also, as you can see, how you pay them, right?
Mm-hmm.
If you pay them just a flat rate a month, you're not paying them overtime. You're better off tracking the actual hours, and then doing the calculation.
You have to
Much
do
better.
that.
But
Yeah.
I mean, what, a 100-year-old lady's supposed to do this? A 75-year-old son's supposed to do this? This is crazy.
I've had every client that I've worked with that said they agreed to this, or they asked for this, and it does not matter what they want. It matters what the law requires.
Yeah, we have a saying in our law firm that consenting adults can do a lot of things in California, but one thing they cannot do is work through lunch.
Yes.
Right.
Very true. Very true. So heading into the next slide. So just to give you a little bit more foundation. So who is a domestic worker? A domestic worker is somebody that performs services related to, I bolded this, care of persons in private households, because that's really who we're talking about today. It's also those who maintain private households and their premises. So it could be the gardener, it could be the maid, it could be the chef, it could be the property manager. But those who are the personal attendants are those who are performing these caregiving services for either young people, people with disabilities or illness, or elderly people. So on the next slide, we go into the definition. So the personal attendants are those who are actually covered by the Domestic Worker Bill of Rights. So you may work in a home, but unless you're a personal attendant, you're not subject to this 9 and 40 overtime. If you're a maid or a chef or a gardener, you're subject to different requirements. So this is only for the personal attendants. So a personal attendant is employed by a private householder or a third-party employer recognized in the healthcare industry, so that would be the agency, to work in a private household. So we're working in somebody's home, we're not in a residential care facility, we're not in a hospital, to supervise, feed, or dress a child or person who by reason of advanced age, disability, or deficiency needs supervision. And those duties include feeding, bathing, supervising, dressing. If the caregiver or the personal attendant is performing other duties more than 20% of the time, and this is on the next slide, then they are no longer considered a personal attendant and they're subject to the different overtime rules. So you can have a personal attendant that helps you cook, helps you clean, helps you do maybe run errands, but you can't have that person do those other duties more than 20% of their total weekly hours, or we're outside of the personal attendant category and they're subject to different rules that have meal and rest break requirements, different overtime requirements.
So we have a question, an anonymous question. How do you calculate a domestic worker's pay if they are a live-in?
Okay. I'm going to go into that because there's a difference between a live-in employed by a third party or a live-in employed by an individual. So a couple slides from now, I'll get to that and we'll talk a little bit further about that.
Great.
Okay. So that's a little bit of foundation. So into my next story, Claire and Robert Sharp, they had directly employed, no agency involved, 2 caregivers, one that worked the week shift, Monday through Friday, and one that would come in during the weekends. Claire was in good physical condition and would take care of Robert during the evening hours, but the caregiver chose to stay on site because they provided a room and the caregiver's home was far enough away that it didn't make sense for that caregiver to go home and come back every day. Robert passed away fairly quickly, and while Claire was sitting Shiva, she was served with a demand letter for into the well over mid 6 figures from these 2 caregivers. She did not have any records of the worker's time. She did not have a written agreement about what the terms of the relationship were. She paid their caregivers a daily rate. The good news in this situation was that Robert had a long-term care insurance policy, which in part of our defending the claim, we try to the extent possible, maximize or at least try to bring in any insurance. So the long-term care policy kicked in a bit. And because there was a bit of the difference between what the policy provided and what the daily rate was, we got the difference, we got the delta. We also tendered to Claire's homeowner's insurance because she was named, remember, she was named and the estate and Robert's estate was named. So we tendered to the homeowners and the umbrella. And miracle of miracles, the homeowners denied, the umbrella kicked in and participated in a mediation. And sadly, Claire just had no capacity to be part of this litigation. She wanted it over as soon as possible. We got into an early mediation just weeks really after Robert passed away. And we were able to settle at the mediation. The umbrella kicked in a 6-figure amount, and Claire had to take a second on her home to pay the remaining amount that was owed. So devastating situation. Right, there was no downtime, and the attorney that brought the claim on behalf of the caregivers, there was no need to do this in the first week after he passed away. There was no need, there was no statute of limitations issue, but that's really kind of how these cases are approached. They're not really given a lot of sensitivity or thought as to the impact on the family.
Pistols at 30 paces, right?
Yes, yeah. So I had mentioned earlier the definition of domestic work employer. So the question is, why is Claire named as the employer? Certainly the estate, Robert's estate, the caregivers were taking care of Robert, but Claire, she falls under that broad definition of any person. So remember, it's not just if you have a corporation, you can shield yourself or any sort of other way to protect yourself from liability. Any person who directly or indirectly or through an agency, through a third party, employs or exercises control over those wages, hours, and working conditions. And she was in the home and she had say over what these caregivers did. And in this case, what they were paid and what hours they worked. And so she was named as an employer. And we've had situations where it's been as far removed as, a cousin who would stop by every so often to check in. Or, I haven't had this, but I've envisioned it, a neighbor, a caring neighbor who would come in and potentially have some sort of exposure. So be careful of that broad definition and make sure that you are indicating in your agreement with the individual who they're to go to if they have a complaint, who their employer is, and that will be at least in a way to try to limit that liability.
So then if I hire a caregiver for, my father-in-law,
Mhm.
and through an agency, and he likes, cornbread and whatever he likes, whatever he eats,
Mhm.
I should give that instruction to the agency, and then the agency instructs the domestic employee. But as the son-in-law, I shouldn't tell them, oh, you're making it wrong. It has to go
Right.
through the agency.
Right. Well,
Okay.
that's where it gets tricky because that's just not,
It's
practical and that's
ridiculous.
not right. But what you want to do if you are having that relationship with the agency, and I represent quite a few agencies as well. So I work with both the individuals and on the agency level, have an agreement where, one party is going to be indemnifying or defending the other in the event of a claim. So you may be brought into a case, but if you have that agreement with the agency saying, hey, agency, you said you were going to do things the right way. And if something happened, you would defend me and indemnify me. You can call on that. So you might be dragged in, but at least you'll have that in place to protect yourself as an individual, as a family member, as just a caring person who's involved in their loved one's attention and care. So there are excluded employers. If it is a referral agency, they're carved out from this domestic worker bill of rights, licensed healthcare facilities, and then clients receiving services through the IHSS, the in-home support services program. Those are not going to be covered employers under this section. And then excluded employees include family members, persons under the age of 18, a casual intermittent babysitter. And that definitely struck with me because I have younger kids who still need babysitters. So I certainly, I'm aware of this. I also have pre-COVID, a part-time nanny who I was very aware of these requirements, even though she worked maybe 4 hours a day. I still didn't want to be hit because I have had quite a few nannies bring similar type claims. A person performing services through the NIHSS program, an individual employed by a licensed healthcare facility, and then certain child care acts, employees of those type of organizations are also exempt. So the next situation, so Rachel came to me after her father passed away. Her father had been living in an apartment in a facility. So even though it was part of a larger facility, he had an independent apartment and he lived on his own and he was somewhat, able to manage his own situation apart from needing this caregiver just to give him a little bit of support. So in that case, even though it was in a larger facility, it was really considered his home. So it was an in-home caregiver scenario. So her father hired a caregiver to provide some support. And after he passed away, she received a demand letter, very, very similar. It looked very familiar. And when I was reviewing it, I said, wait a minute, this caregiver also sounds familiar. And it happened to be one of the caregivers who cared for Robert and had brought the claim against Robert. And while we were in the process of settling that one, took a job with Rachel's father, almost set up a scenario where he was creating liability. He said, pay me this daily rate, pay me in this fashion. Here are my terms and conditions of employment. Rachel and her father didn't know any otherwise, and so they agreed. And he sat there and waited for Rachel's father to pass away. And when that happened, 2 weeks later, the same attorney and the same caregiver brought a claim against a different client of mine. So repeat offender.
So what did they have to say when they saw you? I mean, did you go to mediation? Were they like, oh man, we're outed? Or did they
Yeah.
even care? Or are they just like, yeah,
No.
this is what we do?
The attorneys, I certainly brought it to their attention very quickly. And they took the position that, again, it's not the caregiver's obligation to ensure compliance, it's the employer. They have the burden of complying. And even though the person with knowledge in this scenario was the caregiver, not only did he have knowledge, was in the process of bringing the exact same claim against another family. He had settled that claim out and received a pretty significant payout. And he essentially set up this situation. He entrapped, in my opinion, Rachel and her father to create this situation. And we explored ways to, push back and to maybe bring a claim against him, certainly for unclean hands, but, maybe an unfair business practice or a fraud or a misrepresentation. But, the situation, when you're in this situation, Rachel was so devastated having just lost her father. You don't want to start this full out litigation that's very expensive, untested. We don't know if there's going to be a good result. And it's going to be time consuming and stressful. So it really put us in a very bad position.
I think something, and I will use the term normal people, which what I mean by normal people is non-lawyers.
Yeah.
The non-lawyers who are watching this, something you need to be aware of is the payment of wages in California, or the withholding of payment of wages. That is probably, I can't think of a higher on the list of importance of the functions of the state of California. It's hard to think of something higher than people paying their wages. And that's just what California has chosen to kind of elevate. And, I'll tell you just a super quick story. My grandfather in the 1930s, early 30s, the Depression was just getting started. He dropped out of college because, there was no money. And this is kind of like our family origin story. So he goes from Southern Illinois up to Detroit, works in a factory sweeping floors for a week, and went to get paid. And the guy said, I'm not paying you. And if, tough, goodbye. That's what these laws are designed to protect. They're not designed to protect people gaming the system. And I would say, if you're setting up an elder for gaming the system, it's probably elder abuse, but I mean, it's probably a loser case. We've tried
that, yeah.
Right? It's a loser case because it's labor law. So labor law is like super important in the hierarchy of state functions in California.
You're right. We have also attempted to bring elder abuse counterclaims, and those are hard to prove. And we can't do it in a way that will be viewed as retaliatory for bringing their wage claim. So there's anti-SLAPP type motions that come into play where it's you can't bring a claim just to try to stop somebody else from asserting their rights or pursuing their rights. So absolutely.
And isn't it also true that it's not just, if you underpay somebody, they don't sue you and they say, oh, pay me what I was underpaid. It's that plus.
Yes.
And then if the plaintiff, the person who's suing for the wages, if they get $1, you have to pay their attorney's fees, right? Isn't that the case?
Great point.
So
great point. Yeah.
These are just these, and fortunately you were covered, or your clients were covered by insurance. But I have personal experience with clients. They weren't covered by insurance.
Yeah. Right? I can tell you that was actually a lucky break in that one case where we got the contribution. I've done it in other cases and it's just been a door in our face. There's certainly no guarantee. I will mention that there is insurance called employment practices liability insurance. Expensive, and it doesn't indemnify for wage and hour. Maybe it'll provide some defense costs, your attorney's fees, but it will not indemnify. So you kind of have to weigh the benefit of that. So very good point. And I'll touch on that a little bit further as well, the penalties. So there was a question about what the overtime rules are. So as I mentioned, the Domestic Worker Bill of Rights, effective January 1, 2014, all personal attendants are entitled to overtime at the rate of 1.5 times their regular rate of pay for all hours over 9 or 40. And then that next bullet, consider the federal, is where I mentioned that 40. So we bring it back to 40 in certain circumstances, which I'll talk about. Non-personal attendants are those who are the other kind of in-home workers, are subject to different overtime laws that are under this wage order 15. And then just a note on the next slide is talking about a different scenario. Oh, I'm sorry, I missed that one. So if we have a live out personal attendant, so somebody that does not live in your home at least 5 days a week or 120 consecutive hours, so they come and go, or they have somewhere else where they spend their evenings or part of their day, they need to be paid overtime over 9 hours in a day or 40 in a week. If you have a live-in employed by a third party, an agency, for example, they're also entitled to overtime over 9 and 40. The next slide has the one exception, and this is because under federal law, if you have a live-in caregiver employed by an individual, a family, not a corporation, not an agency, not an entity, then they're entitled to overtime over 9 hours in a day or 45 in a week. So that's where this one time where it kicks in.
So we have a couple of questions. One is anonymous question that says, why does her slide say 45 hours instead of 40 hours? I believe that is the difference between federal and states. So what you have is overlapping, like the United States is 50 states and California is inside of the United States. So federal and California, they kind of overlay each other. Both the state and the federal government have jurisdiction in California.
Yep.
That's kind of a similar idea, as both laws apply and they're not totally synced up. Ed asks, going back to the exempt slide, does exempt mean that those people cannot bring these types of lawsuits against the homeowners' employers? Well, I can't think of any. Probably short answer is no, but do you understand the question?
Yeah, I think I do. But to boil it down, no caregiver is going to be or should be considered exempt.
Right.
So it's almost, we shouldn't even try to make that argument or try and create a situation that would exempt them, because in this case, it doesn't work. We also have tried to make arguments that a caregiver might be an independent contractor. And with recent changes in the law, that's a no-go also. So anybody. Mm-hmm.
Yeah, an anonymous asks, can a personal attendant be an independent contractor if they get to come and go at their convenience and are required to spend no more than 40 hours a week or 8 hours a day? No, that's AB5. I mean, that's,
Yeah.
Sorry.
Very risky. Yeah, I wouldn't try to rely on that at all. And we've brought that argument forward, and it's not a winner.
It's really sad too, because I jokingly said consenting adults can do a lot of things in California. And it's really, to me, I think and probably normal people would go, this is a little overreaching. I mean, come on. So
yeah, absolutely. And part of the legislative history leading up to the Domestic Worker Bill of Rights was that, how can you expect if these large companies with HR departments and advisors and can't comply with all the California's labor laws, how are individuals, homeowners, supposed to comply with, know about, and make these accommodations? It's just impractical and really unreasonable and unrealistic. Just going back to your point about the different laws, being an employer in California is like a puzzle, and putting that puzzle together includes looking at local, state, and federal law, and generally applying the law that's most favorable to the employee, most beneficial to the employee. On occasion, that will be federal. More likely, state is going to be more favorable. And you also have to be aware of local laws. So California has so many locations that have local minimum wage requirements or local paid sick leave requirements. And if anybody wants, I have a chart I put together to help myself and my clients summarizing the local minimum wages, some that are going up January 1, some that go up on July 1st of each year. So I'm happy to share that, and I can forward that.
Nicole, there's a question here. Is Azam asks, is it better to have them be salaried? No, I don't think it's
Right.
It's probably not better.
Right. So that was similar to the exempt question. So usually exempt employees are salaried. And remember, I said that if you're paying any caregiver who's 99.99% of the time, or 100%, I can even say probably, a non-exempt hourly employee entitled to overtime, if you pay them a salary, that salary does not pay them anything for the overtime hours, zero for overtime. And that's again where you get stuck. You might be paying your caregiver a flat rate, let's say $15 an hour for every hour they worked. Let's say they work 24 hours a day. That's great. But that $15 an hour will not cover the overtime for anything over 9. So over 9, you would be entitled to, or you would be exposed to potential liability for an additional half-time premium over that amount.
I'm sorry, somebody asked to go back to a slide and I'm getting lost here. That's why I'm clicking around. Live in versus live out. This is it. Okay. So, and then Ed asks, and I'm going to answer this one. You don't have to answer this, Nicole. Ed asks, what's the name of that slime ball that keeps suing his client?
Oh my
gosh. No, never to hire him. Just you'll have to go offline on that one.
Yeah.
I'll let you handle that. Right.
I would love to be able to.
Let me ask you a question. So if I'm up in I don't know, Sonoma, and I'm hiring somebody, and Sonoma has a lower minimum wage time, and I send somebody into San Francisco, across the Golden Gate Bridge, and they spend 4 hours doing something for me, do I have to pay San Francisco's higher rate for the time that they're in, or not?
That is an excellent question. And a lot of times it will depend on the local ordinance. And some of the local ordinances, or many of them, say that you have to pay the local minimum wage if that worker performs 2 or more hours of work in the work week in that location.
So if you're driving from Ventura County to Orange County and you get stuck in traffic for 2 hours in LA. Okay.
Yeah.
All right.
That is actually an example in the Los Angeles city regulation rules and regulations, talks about driving through the city, stopping for lunch, getting back in your vehicle, and then spending more. Yeah, it's an absolute nightmare. So one way to avoid that is to pay the highest of the minimum wages in every location you expect to be. And then you'll be covered in that respect. That's what a lot of my clients do.
So what if you have, no, I mean, this is a real question. Let's say you have, your mom lives in Nevada. She lives in Reno, and she comes over with her caregiver to stay with you for a week at your house in Sacramento.
Yeah. Yeah.
Are they covered by, or is there some visiting, like, transient rule or something?
Right. So the case law on that, it's the Oracle v. Sullivan case. And at a minimum, we know for certain that an employee performing work in California is entitled to California's overtime laws. Oh. We expect that to be expanded, and we would require, if it was somebody who was eligible for meal and rest breaks, we would also apply that. And so very good question. Again, the risk of that person bringing a claim is probably low if they are spending the majority of their time out of state. Then you would need to look at the state laws where that person is performing their work for the most part. So, very, very low risk in that situation. But if they come out for 6 months, or if they come out for any extended
period of time, or they get stuck with COVID, right? You're out, it's like, oh man, they're stuck. Okay. So Anonymous asking, I know the answer to this, but I'm going to let you answer this.
Okay.
If you pay someone twice the minimum wage rate, can they then be considered an exempt employee, especially if they get to choose their own hours?
Okay, so that sounds like a combo of exempt and independent contractor question. And what I will recommend is that we do not try to make any of our caregivers an independent contractor or an exempt employee, because it's not just the 2 times the minimum wage salary requirement for an exempt employee, it's also the duties test. And they're not going to be performing exempt duties more than half their time. They're probably not going to be performing exempt duties at all. When you're helping somebody bathe and move and eat and supervising them, that's not exempt duties. Exempt duties are the higher level, independent judgment and discretion, decision-making, binding a company, those are the exempt duties. So my advice is, do not try to use the salary exemption. Do not try to use the independent contractor carve out. Pay these people hourly, track their hours, use a timesheet, use some sort of timekeeping. There's apps you can use. There's different ways to do it, and pay them overtime over 9 hours in a day, or depending if what category, 40 or 45 in a week.
And it's also, if you're employing your daughter or your son or your granddaughter or your grandson, that's not, you can pay them a salary because they're an exempt employee.
They're not covered.
They're not exempt. Sorry, I misspoke, but they're an exception to all of these rules. So it depends on on the activities, the wage that you're paying, and it also depends on the relationship of the person. Does that include spouses of children or not?
Yes, yes. So it is, I'm wondering, I'm taking a look, it's parent, grandparent, spouse, sibling, and child. So if you have a cousin, we don't want to try to use that exemption. But if you have a parent, grandparent, spouse, sibling, or child, then we fall into that category.
All right.
So here's a reminder about the minimum wage. As I mentioned, this was just no problem.
That was me.
No, it's okay. That slide was just talking about the fact that, again, a residential care facility is subject to different rules. And, you're less likely to be caught in a situation like we're talking about today if you have your loved one in a residential care facility. So we want to be aware of just the minimum wage requirements for California and for Los Angeles. I put Los Angeles, I'm in Los Angeles, but certainly there's lots of other localities, San Francisco, Berkeley, Oakland, Emeryville, Pasadena, there's all sorts of locations in California. If you're not in one of those locations with a local minimum wage, you look to California, which is going up on January 1. Most of you are going to be, or most of the clients are going to be smaller employers. So it's going to be the lower $13 an hour. And then again, if you're in the local area, you want to pay the lower of that, the local minimum wage.
Nicole, do you see, because I look at these numbers, that's not a lot of money to be in California. Do people actually pay minimum wage, or is it generally above minimum wage? What are you seeing in the real world?
So what I see is people paying quite a bit above minimum wage, but then not paying properly. So that's when it gets very expensive, because then the overtime is based on the much higher rate. So a way to try to account for this financial impact of the overtime is to pay closer to the minimum wage. Okay, so I mentioned that that these employees are exempt from meal and rest break requirements. Certainly you want to have an agreement that says that you can take reasonable breaks during downtime or during naps or that kind of thing. But in terms of meal and rest or meal and lodging credits, this is allowed. You can do a credit against the minimum wage if there's a voluntary written agreement and it's subject to a cap of the amount stated here. They come from the applicable wage order. So wage order 15, they go up every year as well. But this is the cap that you can apply against minimum wage if you're providing certain lodging and certain meals. The lodging does have to be, if it's a room occupied alone, has to be considered private quarters. So you can't give them your couch in the living room. It does have to be something, they can't share a room with somebody who's not a partner of theirs in order to qualify for this.
And so what this means is you can basically deduct their pay $61.13 a week if you're providing a room. Okay.
Right. And then meals.
Same for meals. I got you.
Yeah. Okay. So then
by the way, what is a meal?
What does a meal consist of?
Is for breakfast, could it be like a bowl of cereal?
Yeah, the language in the wage order is kind of vague. It talks about like a balanced, nutritious meal. So, so there's not a lot of guidance. It doesn't have to necessarily be each food group or anything along those lines, but it has to be something that will reasonably qualify as a meal.
Okay.
So the meal and rest breaks themselves these personal attendants are exempt. Non-personal attendant domestic workers are subject to the normal requirements, which are generally the 30-minute unpaid duty-free for every 5-hour work period. And then the rest break is a 10-minute paid for every 4-hour. So what we do for the personal attendants, the caregivers, is we do work in that language about, even though you are exempt from these requirements, you still are entitled to take breaks, like I said, during naps or downtime or other time that makes sense. One thing I want to bring up that I don't think I touched on was prior to 2015, there was an open question about whether employers in this situation could carve out sleep time. So if you had somebody living with you, could you carve out up to 8 hours of sleep time if they were able to use that time for their own personal reasons? And a case came down in 2015 that clarified, it's called Mendiola, and it clarified that if this specific wage order does not provide for this, you cannot do that. And that got a lot of employers in trouble, of employers of caregivers, because they continued that practice. And in actually the first case I told you about, Sonia, the agency crossed out on the time card the period for sleep time and said unpaid sleep time, even though this was after 2015. And that was not consistent with the law, and that those people are entitled to be paid. So essentially, if you have the caregiver, if they must be on the premises, they must be paid for that time, even if they're sleeping, even if they're reading a magazine, even if they're talking on the phone. It's totally personal time, but if they have to be there, they have to be paid. And so for Robert and Claire, we had Claire in decent shape and she would care for her husband during the evening hours. But the question was, well, if the caregiver wasn't there, would you, or chose to go home for the night, would you bring in somebody else to be kind of the backup? And they told me yes. So if that person, if you otherwise would have brought somebody in, really they were required, whether or not they were called to actually help you out or perform work twice in 2 years, really you needed somebody to be there, because if they weren't there, you would have brought somebody else in to be your backup.
So Ed has a question. My mom is paying for 24/7 care for my stepfather. If after this webinar, we discover she has not been paying correctly, can we fix it to avoid a problem later? Pay retroactively, perhaps. I would say, Ed, reach out to Nicole, and absolutely, you need to check this out. And if you can talk about that, Nicole, they should. I'll let you answer that.
Yes, it's a very good question, and there are ways to address it. You want to, of course, do it carefully so you don't kind of push that person to go talk to an attorney. But there are ways to calculate, to try to remedy or to make that person whole, and then to potentially get a release. And the release would be, you can release most claims, not all claims. But what you would be doing is you would be saying that this is what we've calculated, and then anything beyond that is in dispute. And so we're releasing those claims. And the reason why you can do some of the penalties that you mentioned, you can release that, is because they're not automatic. They're defenses to the penalties. So either it wasn't willful or they're discretionary. And so if it's not a guarantee that the employee is entitled to that amount, that is another basis to waive or release that claim. Okay, so some of the other requirements that that we should keep in mind are, I mentioned paid sick leave. So California has a paid sick leave requirement for all employees, even if you are part-time, even if you're seasonal, even if you're temporary, and it applies to all employers, even if you only have one employee. The California requirement is 3 days or 24 hours, whichever is greater. And then locally, it's more. So for example, in Los Angeles, it's 48 hours. So my part-time nanny was entitled to and was provided 48 hours of paid sick leave while she was working for me. You do not have to pay it out on separation, but it does need to be provided. It should be on the pay stub if you provide a pay stub. There are exceptions to the pay stub requirements for individuals who employ a caregiver, not for agencies, but that's something to be aware of.
Can you talk about the importance of properly filling out the pay stub?
Yeah.
All the bad things that can go wrong.
Yeah. The pay stub the requirements are generally under Labor Code 226. There's a long list of requirements. The good news is that if we are an individual and they're performing services in our home, then we do have an exception. But if we are retaining that person through an agency or any sort of third party, very strict requirements. And if one thing is wrong on that pay stub, there's a penalty. So very important to pay attention.
I know of one case where this was a person who employed people in a business. They paid the overtime, but they put the overtime in the regular pay box and the overtime was left blank. So all that did was juice up the average hourly rate,
man.
and it was exponential, and it bankrupted the company.
Oh man, that's awful. Yeah.
But people got paid. The crazy thing is the people were actually paid their overtime, but it still bankrupted the company.
So yeah, that's why a lot of these labor code provisions are so hard to have strict compliance and yet so easy to attack an employer on. So just going down the list from the last slide a little bit further. So the California Fair Employment and Housing Act, FEHA, that generally applies to employers with 5 or more employees, but the harassment portion applies if you just have 1. So I have not seen it, but it is possible if you just have one caregiver, that they could potentially bring a claim for harassment. I talked about the insurance. So one thing to absolutely put in place is a workers' comp policy. You can do this as a rider to your homeowners. But if that caregiver gets injured on your property, you want to have that coverage. Some homeowners policies already have some workers' comp type coverage, for a personal injury woven in, but it's not that costly, and it's very helpful to talk to your broker about putting that extra little bit of security on. I mentioned the employment practices liability. Again, there's pros and cons to that. I've even had some brokers say that they can't get it for an individual. And my thinking is, well, how can they be sued as an employer, but can't get coverage as an employer? So I don't love that, but again, it's something to explore. What I've been told by one broker I talked to about this was to look into the workers' comp rider on the homeowner's policy and an EPL rider on the umbrella policy that's in place. And so that would be a way to try to work that in. We talked about the Labor Code 226 wage statement requirements. And then there's also posting requirements and new hire documents. The I-9 form, that's required, even if you just have one. Certain notices are required. Now, you don't have to go through the whole putting that huge document on your wall in your kitchen, that we see in a lot of workplaces. But some of the documents do have to be provided. And so you want to be aware of that. Again, the potential exposure on those particular claims are very, very low, but if you want to be as compliant as possible. So what is the potential exposure? So I've had caregivers bring claims before the Labor Commissioner. The Division of Labor Standards Enforcement is the Labor Commissioner. They on their own can go to that office and can fill out a form. And there's a process that there's a conference, possibly a hearing, and that's a way for somebody to try to recover. A civil lawsuit, finding a plaintiff's employment attorney, telling them, I don't think I was paid properly. I was paid a flat amount per day or per week. I was never paid time and a half for hours over 9 in a day. And then the damages that can result from that are the overtime, which we've really spent a lot of time talking on. The liquidated damages is an additional penalty for not paying minimum wage. Statutory penalties can include, Labor Code 203 is called a waiting time penalty. So if you don't pay an employee everything they're owed at the time of separation, then their wages continue to accrue every day capped at 30. So that's another penalty that can be quite high. I haven't seen this much, but there's the Private Attorneys General Act, PAGA. For larger employers, it is the bane of our existence. It is something where you can get additional penalties stacked on other penalties. There's a whole bunch that goes into that, but it's something, again, that is an issue and can certainly be raised. And then interest and then attorney's fees, which Jim mentioned earlier, that's the driving force. If these employees bring their claim and they prevail, which they oftentimes will be able to if they're not paid properly, which is often the case, then they get their attorney's fees paid. And so not only will you as the employer have to pay your attorney to defend you, you will have to pay their attorney to bring their claim on their behalf. And that's where it gets very expensive and really where they have the leverage over us, on the defense side. So what can you do to protect yourself? One, again, knowledge is power. Now you have a whole bunch of knowledge that will hopefully help. Consider and be aware of potential joint employer liability. So again, we have the agency, we have a third party. You could be a joint employer even if you believe that the other person or the other entity is solely responsible. With the agency relationship, make sure that they're doing things properly. Audit them, have them report back to you, and then potentially put something in writing as to if there is a claim, how is that going to be handled? Are you going to defend me? Are you going to indemnify me? How does that look? Put an employment agreement or certain policies in place. Does not have to be a 10-page document. You don't need to have a lot of detail. It can be as simple as maybe a page or two, just with the basic language. You're at will. This is how we're paying you. This is how we're handling breaks. You must record your time, a little bit about paid sick leave, just a very, very brief. Timekeeping is critical. We need to have records of the hours that the employee worked and have the employee fill out that time record, not the employer filling in 8, 8, 8, 8, 8 each day or 12, 12, 12, 12, 12. We need to have the employee marking their start and end time. And it shouldn't be the same every single day because nobody works exactly 8 to 5 or exactly a set amount of hours. Keep records of payroll as well. And then we had talked about, how do we protect ourselves? Well, if somebody separates from you, or if you believe that there's been something that needs to be corrected, look into a severance agreement or a release. Too many times clients have come to me and said, when we parted ways, we gave them a generous thank you. And that's great. But if you give that thank you and you don't get that release in exchange, you're out of pocket a whole bunch more than you would be otherwise. And then lastly, this definitely goes to Jim and your firm, protect your assets. And I know that there are really creative and really smart ways for people to take steps prior, upstream, to protect their assets, protect their trust, protect whatever that their estate plan from attack by a former caregiver. So I hand it back to you. I think that that's the next step, is to speak with you. And if there are any other questions, I'm happy to answer.
Great. So we have a Q&A. You can go ahead and put your questions in the Q&A and we'll answer those. Just to let you guys know, if you need help with the legal affairs related to caring for a loved one, go to Cunningham Legal, make an appointment. We just block out an hour at a time, bring all the data, and there's a charge for that. But at the end of the meeting, you'll know whether to take action or not. So do I need to do something? If specifically you're like, I really need to hire Nicole to get that, the ed, I really need to hire, just contact her directly, and you can, her information is at the beginning.
It was, yeah.
It was at the beginning. But go ahead and I guess Google Fisher Phillips and Nicole Kamm.
Yeah, and Kamm at
What
Fisher
is your,
Phillips.
you want to just maybe say what your phone number is so they can reach out to you, or your
yeah.
email? Yeah.
My cell, which is the best place to reach me these days, is 818-262-6093. And my email is nkamm, NKAMM @fisherphillips.com.
Great. So we will open it up for questions. We'll give you guys a couple of minutes, but boy, this has been just really great. You probably scared a lot of people. So let me ask you as we close here. If I've needed to hire an elder, a caregiver for an elder, should I go through an agency or should I try and do this all on my own? What do you recommend?
I don't think that there's harm in using an agency. I just think that relying solely on the agency to be in compliance and to also be looking out for your best interest in the event of a potential claim. I think that we need to just be more aware of what might arise. And so, talk to an attorney to vet that agency, or to double check, to audit how that agency is operating. That would be something that I would strongly recommend.
And if you would like to do asset protection, go ahead and shoot us an email. We can schedule a time to meet with you about asset protection. So there are some great asset protection strategies for California residents. Ed says, I'm terrified now. I guess I better figure out what all my mom's agreements have been with these people. They're wonderful, but they're wonderful now. When they're done, who knows? Ed, you're 100% right. And so in the context of this, on a very high level, which is Captain Obvious, these cases arise after the person they're caring for typically passes away. So these people are out of a job. Yeah. And many times they get attached to the people that they care for because, right? I mean, these are, in my experience, generally good people. I mean, you get a few bad apples in there, but they're generally good people. And they generally feel really, committed to the person they're caring for. And then, sort of the rugs strapped out from under them and they don't have a job. And that's maybe more generous than actually happens in the real world. But, I think it's something that you need to, what do they say? Trust but verify.
Right.
Connect it. You know what I'm saying?
Yes. Yeah. I'll add one more point to keep in mind. This is not something that they can go back indefinitely and try to collect. The max that a caregiver can go back is 4 years to try to collect unpaid wages. So if, we wouldn't have to be calculating or trying to reconcile, if this person's been with you for 10 years. So if that's a little bit of a benefit, but yes, absolutely. Unfortunately, doing what I do, I've learned that no good deed goes unpunished. So a little cynical, but
Well, that's
absolutely.
that we say that in our firm too. If your significant assets are already in a living trust, are those assets protected? No. You need to do something else. A living trust provides no asset protection.
Wow. Yep.
Very important to understand. Okay, on that happy note, we will end it. Thank you, Nicole. Thank you so much for spending time with us.
Thank you
And
for
I
having
hope
me.
that everyone has found this helpful.